Everyone, thank you for coming tonight. We're here to talk about just cause. I'm Lena Fader, and I'm the Audience Development Director at The New Yorker. I'm a Vice Union on the New Yorker Union's Unit Council and a member of the News Guild of New York's Executive Committee. So we're talking tonight about just cause and why it matters. In our contract, it's just a single line, a very simple proposal. It says simply, there shall be no discipline or dismissal without just cause. This provision ensures due process, promotes equity and accountability, and makes standards transparent for all. Some of you may recall that this was a huge battle for the New Yorker Union. It took well over a year for us to win it. We faced bosses who said that just cause poses an existential threat to the magazine itself. And we have seen that a number of management side attorneys have joined together to try and gut just cause as an industry standard in union contracts. Our bosses said that this would undermine editorial standards, that the arbitration aspect of just cause doesn't work in creative industries, that we'd be weakening our publications completely. And we saw that management teams started proposing just cause with an editorial exception, which is a big loophole, essentially rendering just cause completely useless because they can claim that anything is due to editorial standards and thus they have no obligation to be transparent, and the Guild has no recourse for articulating why these decisions were harmful and inappropriate. But we mobilized, the entire News Guild of New York mobilized. So we were with our pals at BuzzFeed News, New York Magazine, Ziff Davis, Quartz, Pitchfork, and Ars Technica. And we held a guild-wide campaign to show all of our bosses why we were going to demand just cause in our contract. And we eventually won, thanks to our solidarity and thanks to Elizabeth Warren and Alexandra Ocasio-Cortez pulling out of the New Yorker Festival to stand with us to demand just cause. So tonight we're going to keep talking about why this is such an essential standard of union contracts and how to leverage just cause to win discipline cases. This training is part of News Guild Strong, an initiative dedicated to offering the tools, training, and support to create member-driven unions. And we have one more event in this series. Mark your calendars for June 28th on past practices. Please make sure to include any questions you have in the chat, and we'll make some time at the end of this presentation to get to your questions. Now, to introduce tonight's trainer, Robert M. Schwartz is a retired labor lawyer who has represented unions for over 40 years. He's also a noted author who's written a number of best-selling books, and I've got several of them here. They're amazing. You can get them all in the Labor Notes store. I believe we will also be placing a link in the chat for these books. So tonight draws from his books, and it's useful whether you're a new union steward or simply just want to know how the mechanics of just cause work. It should be really incredibly helpful. So thank you all for being here tonight, and Robert, please take it away.
Thank you very much. Thank you, Chris, and thank you, Lena. So this is the second of the workshops, and it's a topic which I enjoy speaking about because there's so much to just cause. There's so much to talk about. We probably won't be able to cover the whole topic within the time that we have. We'll probably be able to cover 70 or 80%, however. First, let's start out with some facts. Just cause is present in almost all union contracts. Probably at least 90% of union contracts in the United States have a provision that requires the employer to prove just cause before the employer imposes discipline or discharge, and which allows the union to take cases to arbitration, that is, to be heard by a neutral expert on labor relations who can make a new decision as to whether, a fresh decision as to whether an employee should be disciplined, what should be the level of discipline, or in those cases where the employee is discharged, whether the discharge should stand. We win most discipline and discharge grievances. We win most discipline and discharge arbitrations. I believe the numbers are well over a majority of the arbitration decisions that deal with just cause are in favor of the union. And the reason we win so many cases is that we've become quite expert at developing and building a case, investigating a case, building a case, and presenting cases. Unions have put a lot of time and a lot of energy, and that knowledge which they gained through those cases is easily transferable to other unions or to new unions. By the way, what is a victory in a discipline and discharge case? If an employee is discharged and we go to arbitration and we convince the arbitrator that there was an abuse of justice, that the employer did not have a basis to impose such a heinous penalty, discharge, deprivation of employment, and we convince the arbitrator to reduce the penalty perhaps, say, to a 2-week suspension, or maybe even a 30-day suspension, because let's assume that the employer has some proof that the employee violated some important rules or standards of conduct. Is that a victory or is that a defeat? We didn't get the employee reinstated with full back pay. That was our goal. Instead, we got the employee reinstated with maybe 90% of the back pay that the employee had lost. I don't think that's a defeat. I count that as a victory. I think if we can get a penalty substantially reduced, we've done a service for the employee. We've saved the employee's job. The employee can continue, if he has a career at this workplace, to build that career. Moreover, in many cases of especially discharge, we are able to qualify the employee for unemployment benefits while we're waiting for the resolution of the case. And in many cases, the unemployment benefits are 60 or 70% of pay. So oftentimes the employee walks out of the case, whether he wins completely or wins reinstatement, wins transformation to a short-term suspension, the employee is in pretty good shape. Now, there are some unions that don't have just cause. The main union group that doesn't have just cause in the United States is the construction trades, the iron workers, the carpenters, the glaziers, the unions that represent workers who build buildings and build houses and build large-scale construction sites. For one reason or another, those unions have not insisted on just cause in their contracts. One reason might be that the workers, in many cases, don't assume that they're going to be working for the same employer for their lives or even for a long time. They move from employer to employer. Second of all, the workers can generally get another job fairly easily by going down to the union hiring hall, putting their name in, and waiting for the hiring hall to call them to another job. And thirdly, the workers are quite expert at collecting unemployment benefits. So perhaps those are the reasons. But for the rest of the workforce, just cause is the norm. Some unions have slightly different language. Most unions say no discipline without just cause. Some contracts say no discipline without proper cause. Some union contracts say no discipline without good cause. They all mean the same thing: good cause, just cause, proper cause. When the cases get heard, the arbitrators apply the same standards to all three. So if you have an employer who fights like crazy to get your language changed from just cause to good cause, and some employers will go crazy to make that change, then they are surprised later on to find out that it changes nothing, that proper cause is applied in the same way as just cause. I would say that just cause started showing up in union contracts in the 1930s and the 1940s. And in the beginning, it was a little hard. It wasn't easy for unions to build their cases or to organize their cases because there was no definition of what just cause really meant. And every arbitrator who heard cases had his or her own definition of what just cause means. Some arbitrators might say, I can't define it. I can't say exactly what just cause is or what amounts to just cause, but I know it when I see it. And I know it in my gut that in this case, the employer didn't have just cause, or in this case, the employer did have just cause. Well, that wasn't a very satisfactory way. We didn't know how to investigate cases. We didn't know how to present cases in an effective manner. In 1964, an arbitrator in Chicago who sympathized with the union problems in building just cause cases issued a 7-part list of the elements of just cause. He called it the test of just cause, the 7 tests of just cause. The arbitrator's name was Carol Dougherty. And Dougherty attached his list of 7 tests to every decision that he wrote. And that list caught on. And unions began using it in other cases and going to other arbitrators and say, see, this is the 7 tests of just cause that Dougherty agrees with. It makes sense. I hope you would apply the same 7 tests. And many arbitrators did begin to apply the same 7 tests. And many of the tests were good tests, at least from the union point of view. They put a burden on employers to justify, a heavy burden on employers to justify discipline and especially discharge. The problem was that some of Dougherty's tests weren't really carefully thought out. For example, one of his tests is that the employer must have done a complete and thorough investigation before announcing discipline. Well, that's a laudable concept and we agree with it, but as a test of law, it's very difficult. A union can always show some weakness in the employer's investigation. No employer interviews every witness or examines every document or reviews every part of an employee's prior history. But when the employer in all cases, we can make the argument that there was not a thorough investigation. But arbitrators don't like to give us the case just based on that fact. The fact that the employer only interviewed 4 out of 5 witnesses, didn't do a totally thorough investigation. Arbitrators don't want to give us that case because if in fact the employee did commit a serious infraction of the rules or a serious form of misconduct. As time went on, arbitrators began to sort of turn against the Dougherty test and to reject them. Some arbitrators became so upset with the Dougherty test that if you went to an arbitration and mentioned the Dougherty test or mentioned the 7 tests of just cause, they almost threw you out the room. They said, I make my own decisions. I don't go what some Chicago arbitrator tells me to do. When I researched the book that I wrote on just cause, I assumed that I'd be just dealing with the 7 tests that Dougherty had issued. When I discovered that his test was so unpopular, I decided to look into it much more deeply. And what I came up with was a different concept. The principles of just cause as agreed to by the majority of labor arbitrators in this country. And I came up with 7 principles of just cause, or what I call the basic principles of just cause. Next. Chris, next. Well, okay, here we go. Okay, so this screen gives you the basic principles of just cause that I came up with during my 5 years of research into thousands and thousands of arbitration decisions. Very quickly, 1, employers must inform employees of workplace rules. If the employer has not informed employees of workplace rules, the employer has not satisfied this basic principle of just cause, and we should win the case. 2, employers may not penalize employees for violating previously unenforced rules. 3, employers must follow due process. 4, and we'll explain what that means. 4, employers must have substantial proof of misconduct. And that brings up the whole question, for example, of hearsay evidence. 5, employers must treat employees equally. We win a lot of cases based on number 5, because for one reason or another, it appears that almost no employer in the United States can avoid favoritism, no matter how hard they try or instruct their supervisory staff. Next. 6, employers must apply progressive discipline. And by the way, that principle applies whether or not the phrase progressive discipline is in the contract. Some contracts spell out progressive discipline as a 4-step process of warning, oral warning, written warning, 1-day suspension, 5-day suspension, discharge. That would be 5 steps. But many contracts don't spell it out, explain it, or even use the word progressive. Nevertheless, the great majority of labor arbitrators insist that an employer apply progressive discipline as part of the notion of just cause. And last, employers must consider mitigating and extenuating circumstances before they make the decision to issue serious forms of discipline, such as suspensions or discharge. We also win many cases on number 7. So what we have here as basic principles also constitutes a checklist. And my suggestion to you is that you use the 7 principles, the basic principles, as a checklist when you investigate your next case and the case after that. That you interview the employee and others to see whether you can build a case for a violation of any one of the 7 principles. If you find 2 or 3 that have been violated, that haven't been satisfied, that's your case. You build your case on those 3. Some advocates have a different approach. They would argue that we're going to build a case for all 7. We're going to go into arbitration for grievance or arbitration. We're going to argue that on every one of the 7 requirements, the employer didn't satisfy the needs of the test. I prefer personally, and I've had much more success by picking out your strongest point, maybe your second strongest, at best your third strongest, and then I rest the case. Next. What I'm going to do now is go through the 7 tests. And by the way, let me say 1 or 2 words on these principles before I go into the specifics. These principles were developed over many years. These principles were developed through many thousands of labor arbitrations on the issue of just cause. It fills the books. You can go to libraries when they still had books, and there were scores and scores of arbitration manuals filled with decisions on the issue of just cause. Just cause is probably the largest reason for us to take cases to arbitration and to get written decisions from arbitrators. And over the years, we have been very successful in arguing that just cause requires a multifaceted approach, and that it includes at least these 7 basic principles. So you can thank all the union people who came before you, and all the advocates and all the officers for doing the good job that they did to develop this area of the law, which now we can generally use in a very successful manner. Okay. Back to the particular basic principles. The first basic principle says that an employer may not discipline an employee for violating a rule or standard whose nature and penalties have not been made known. Well, this is a sort of a common sense principle. It's not fair to impose a penalty on an employee for violating a rule if that rule was never explained to that worker, and if the penalties for violating that rule were never explained to that worker or to that employee. And we used to win quite a few cases on the issue of lack of notice. But at this point, we don't win as many because most employers have become a little more sophisticated. They take all their rules and they put them into a rule book or a manual or a handbook. And they take that handbook and they give it out to employees when they're hired. And whenever they make a new rule, they print that one out and they hand it to employees. And they often ask the employee to sign a receipt that they received the rule book. In these situations, it's rare that we actually win a case on failure to publicize company rules. Now, sometimes we have a member who is fired, and he's very insistent that that they were never given, that he was never given the rule book. He doesn't have the rule book. He never saw the rule book, and it was never explained to him. Well, if that's true, we have the possibility of a case on notice, on proper notice. But when we check it out, and we should check it out, and one of the best ways of checking it out is to make a demand on the employer to give us a copy of the receipt signed by the employee, which verifies that the employee received a copy of the rules. If the employer can't give us that receipt, then we could possibly proceed on lack of notice. It's also important to understand that not every rule has to be in the rule book. There are some rules which are called self-evident misconduct rules. There are some rules of conduct which every breathing worker or employee should know when they take a job. For example, stealing. The employer doesn't have to put that in the handbook because every person who takes a job knows that it's not proper, it's wrong, it's very wrong to steal items from the workplace for your own use, without to take items without permission. So there are a number of items which don't have to be in the rule book, and the employer can still enforce them. Assaulting other employees doesn't have to be in the rule book. Sexual harassment doesn't have to be in the rule book, although it usually is, because that's self-evident misconduct. What has to be in the rule book are those rules which are not self-evident, which are not common to the knowledge of almost all employees. Insubordination, by the way, oftentimes, and that's a very common form of discipline, that an employee is disciplined for not obeying a direct instruction or a rule given by a supervisor or a manager. Sometimes we go to the rule book and we don't find insubordination in the rule book. And we might think, wow, we can win this case because it's not in the rule book. And this employee was never given a lecture on insubordination. So we should be able to say that this employee was not made aware of the rules. On the other hand, most arbitrators would say obeying the instructions or the orders of a supervisor is self-evident. If you work, you should know that. It's common sense. Let's go to the next. The second basic principle of just cause is called prior enforcement, or it could also be called recent enforcement. And it says that an employee cannot be penalized for violating a rule or standard that the employer has failed to enforce for a prolonged period. We win a lot of cases under this topic because there are certain situations where employers frequently take advantage of workers and penalize them when they haven't been doing it for quite some time. One of the common situations where this arises is when a new owner takes over a business, a newspaper or a factory, and the new owner is determined to do things differently, to play by the rules, to put the ship in the right order. Or sometimes it happens when a new supervisor takes over a department, and that supervisor is determined to have the employees follow every rule that's in the handbook, and starts to impose penalties for violations of rules that had not been enforced for many months or even years. When an employer fails to enforce its rules, we call this lax enforcement. Lax enforcement. Or another name for this is negative notice, because you have to give notice, but then when you don't enforce the rules, you are in a sense wiping out the rule. You're putting an exit into the rule. You're canceling out the notice that you put into the employees into the handbook. In order to win a case of lax enforcement, we need generally to show that a rule has been violated by a large number of employees, by a fair number of employees over a prolonged period. So that the employer was aware of these violations, because if people are violating rules and it doesn't come to the attention of the managers, then it may not be negative notice. Then the employer can say, well, they were violating the rule without my knowledge. They were violating the rule surreptitiously, and I should still be allowed to enforce the rule. On the other hand, and sometimes employers will say, well, okay, the rule was violated, but it didn't come to the attention of upper level management. Oftentimes arbitrators will say that the union has to show that at least middle level management or upper level management were aware that this rule was being violated. So for example, if you have workers who work the 3 to 11 shift, and because work is very slow on the 3 to 11 shift, workers have been allowed to leave at 10 minutes early or 20 minutes early when there's no work that needs to be done. So they're not finishing out their shifts. And this is because one particular supervisor is allowing it to happen, and no one else is aware of this. We may not win that case because the only person in management who's aware of the violation is a low-level supervisor. And generally, arbitrators insist that that the rule violations be known by middle or higher level management. Another issue that comes up when we try to win a case on lax enforcement is that in order to prove that rules have been violated as a general, in large numbers over the previous period of time, we have to have eyewitness. It's not enough for a worker to say, well, yes, I left the building during my shift, and I went out and had a meeting with my lawyer or with my some business I had on the side. But this happens all the time. Many workers leave during their shifts and do private business outside the workplace. It's a common occurrence. It may be a violation, but it's a common violation and it occurs widely. Well, that's not going to be enough, probably, to win the case. Management is going to deny that this happens. They're going to say they never saw this happening. And just the fact that a worker says it happens is probably not enough. Because in these kinds of situations, the employer is allowed to insist that any witness who is testifying that it happens widely give names of workers and dates and prove that, in fact, other workers are violating the same rule. And many times, the best way we have to show that there's been rule violations is for the steward himself or someone in the union himself to take the stand and to say that, yes, there's been common rule violations and that I have been taking part in those violations and nothing was said to me and there was no penalty put on me. That provides the prerequisite to prove a case of lax enforcement. Now you might say, well, how can we do that? How can we go to an arbitration and put on witnesses and give names of other workers who committed the same level of misconduct, who also extended their breaks from 15 minutes to 30 minutes or whatever the misconduct is? Are we going to get those workers in trouble? If we put a case on that says that other workers committed the same violations without penalty, can we get those workers in trouble? Can the employer say, oh, well, I didn't know about that. This is all a big surprise to me. You're telling me that the following 5 workers did the same thing, that they were told to have their stories in 8 hours. They didn't do it. They submitted their stories in 12 hours and nothing happened to them. Well, I didn't know about that. I didn't know that was going on. I'm going to check into it. I'm going to do an investigation. I'm going to call those workers in. And if it turns out that it's true, that they committed the same violation, we have a strong rule that says you must get your stories in within X number of hours. They didn't do it. They admit to it. I will impose the same penalty on them as I'm imposing on the employee in front of me right here. In other words, can we get other workers in trouble when we argue lax enforcement? My answer to that is theoretically it could happen, but in practically speaking, I have never seen an employer take that road. Here, a union present a case in a grievance or an arbitration and follow up by bringing in these other employees who were cited by the union and then punish them. It's not good form. It doesn't look right. And perhaps more importantly, we can take those cases and probably win those cases in the grievance and arbitration system also. And the way we would win those cases is by relying on a due process rule, which is widely agreed on as part of due process, that an employer must take action promptly after it becomes aware or should have become aware that the employee had violated a workplace policy or rule. So if an employer, through the grievance and arbitration process, determines that 6 months ago other workers violated the rule, or 3 months ago violated the rule in an open fashion, and no action was taken, that employer is not really in a position to go back now, 3 months later, 6 months later, 1 year later, and impose penalties. That is not prompt discipline. That is a violation of due process. The second part of prior enforcement, that we have to prove not only that other employees have been violating the rule extensively, but that the employer was aware of it. Now, sometimes the employees violate rules right in front of the supervisors. If they're leaving the premises during the work shift, the supervisor probably sees it. In that case, it's not so hard to prove knowledge on the part of supervision. But in other cases, we can't do that. In other cases, we don't have good proof that supervisors observed other employees violating the rule. In those cases, we rely on a different concept that's called constructive knowledge. And that concept says that supervisors are expected, by the definition of their jobs, to supervise their departments. Supervisors are expected to know what's going on in their departments. Supervisors are expected to inspect, to check, to observe. And consequently, if the union can show me that there was open violation of company rules or workplace policies, then I am going to assume that the supervisor was aware of it, because that's the supervisor's job. The supervisor is to be expected to be aware of rule violations which are common or widespread in the workplace. Let's go to the next. Okay, that we can now go into due process in a little more detail. Due process is one of the 7 basic principles of just cause, but due process has several subparts. First part, an employer must conduct an interview or hearing before issuing discipline. That's number 1. 2, the employer must take action promptly after becoming aware of misconduct. And 3, the employer must list charges precisely in the notice of discipline given the employee. Lastly, once assessed, discipline may not be increased. Those are 4 separate elements of due process, but I'm going to focus mainly on the first one. An employer must conduct an interview or hearing before issuing discipline. Why is this such an important part of due process? Because it's basic fairness. Basic fairness says that before you punish someone, you give that individual an opportunity to present his explanation or her explanation of what happened, to give his or her side of the case. And this is a well understood principle in criminal law and all other areas of the law. It's not fair to take action before you allow the employee to explain what happened. And it's not fair to make a disciplinary decision until you interview the employee. And when you interview that employee, you need to have an open mind. It's not fair to make your decision in your mind and have a decision made, then interview an employee only in order to verify that decision. You must go to that interview with an open mind. For example, if we find out that a supervisor has written out a discharge statement before the interview, well, that supervisor obviously doesn't have an open mind, and he's just conducting the interview to justify a decision he made without hearing from the employee. Why is it so important to interview an employee before making a decision? In many cases, the facts are fairly well known. So let's take an example. Let's say that an employee is accused of insubordination, because a supervisor says, I gave the employee a clear order, and that order was to interview 3 witnesses to a car accident, and the employee only interviewed one of those 3 individuals, and consequently, I'm imposing a 2-week suspension for insubordination, failure to obey a clear order on the part of management. So you might say, well, you did, we take the case up and we go to grievance step 1, and we make our first point that you didn't interview that worker. The supervisor gave you a report. Maybe the supervisor wrote it up as an incident report. You immediately determined to impose a suspension on that employee. You called the employee into your office and you suspended him, or you called the employee at the employee's house and you gave him the news on the phone. The employer's reaction to this point can't deny that that's what happened, but the employer says, well, I didn't need to interview the employee. I knew exactly what happened. There's no dispute. The supervisor gave him the instruction. There were witnesses to the instruction. There was another supervisor in the room when the supervisor gave the instructions. The employee, there's no dispute. The employee only interviewed one of the 3 witnesses. The employee has never denied that that's what he did. There was no point in conducting an interview. It'd be a waste of time, waste of my time. So what's our answer to that? Why is it necessary to conduct an interview in a situation where the facts are clear, the facts are well established? Why does an employer have to sit down with an employee in a calm fashion and explain to the employee what the charges are and allow that employee to give his or her explanation? And the answer is, in a nutshell, many times the employer does know what happened. It's apparent. There were witnesses. It was open and obvious. So yes, many times an employer does know what happened. What an employer does not know is why it happened. And why it happened is just as important as what happened. Because why it happened goes to whether it is proper to impose a serious penalty on this employee, whether this employee is aware of the rules, aware of his or her responsibility, whether this employee is oblivious, whether this employee could care less. It goes to whether it's proper to impose a substantial penalty. Many times, if you interview the worker, you find out that there was other factors at play. There's a reason why that worker didn't interview only interviewed one of the 2 witnesses. There's a logical reason. There's a fair answer to that. maybe after interviewing one of the employees, that employee got a call from his husband or from his wife that there was a major accident involving one of the children, a major problem, and that employee had to run home to deal with that. Well, that may or may not justify not finishing the job, but it's a factor. It's a legitimate factor to consider before you determine whether this employee really was guilty of misconduct and what type of misconduct. So arbitrators over the years have been convinced by union arguments that it is an absolute necessity to conduct an interview before issuing discipline in order to find out why events occurred. And if we can establish that the employer didn't conduct that pre-disciplinary interview, we have a good shot at winning the case. Now, winning the case in this context doesn't mean getting the employee back on the job with full back pay, because in these situations, oftentimes the employee did commit some serious level of misconduct, but the employee has an explanation as to why that happened. That has to be taken into account. And usually in these situations, by raising due process, we are able to get the disciplinary penalty reduced. We don't get it voided, we get it reduced. And in particular, on discharge cases, we are able to get the penalty reduced from a discharge to one step below a discharge, which would be a suspension. The second part of due process, as I mentioned earlier, is that the employer has a duty to take action promptly after becoming aware, not 3 months later. You know, so if you're a reporter and 3 months ago they get alerted to the fact that on one of your stories you didn't, there was plagiarism, or you didn't do the interviews you said you did, and they sit on it for 3 months. That's not taking action promptly, because they sit on it for 3 months. They call you, they bring you in, they impose a penalty, and now you're expected to defend yourself as to what happened 3 months ago. People's memory isn't good. You can't. The witnesses, it's not easy to find witnesses to what happened 3 months ago. The witnesses don't quite remember what happened, and you're at a disadvantage. And consequently, the rule has developed that an employer has a legal obligation to take action promptly after becoming aware. List charges precisely, that's sort of a common sense rule. The last point is interesting. Once assessed, discipline may not be increased. And the concept here is that it's double jeopardy is really the concept. Once, we all know about double jeopardy. I mean, it came up in the O.J. Simpson case. You can't try a person once and then fail to convict, and then try him again and get a conviction. You can't do that. Once a proceeding is over, it's over. And in the industrial workplace, it's not quite exactly the same as the criminal courts, but once discipline has been assessed, now once an employee has been believes that he has been disciplined, or she has been disciplined, and she's serving her time, and she's going back to work, and she's back to work, the employer cannot reconsider the case and decide to impose a more severe penalty. So once an employer gives an employee a written warning, and then let's say a higher level of management gets involved and reviews the matter and says you were too lenient on that worker, you gave that worker a written warning, you should have given that worker a 3-day suspension because this worker had done the same thing twice before. Can human relations now call you in and say we made a mistake, or this supervisor made a mistake? We gave you a written warning. He should have given you company policy and progressive discipline. We would say this would be a 3-day suspension. So we're going to change the penalty to a 3-day suspension. So that won't hold. That would be a violation of due process. You issued the penalty. The employee had no reason to believe this was going to continue. The investigation was going to continue. The employee had every reason to believe that the matter was finished. Discipline had been imposed, and that's that. So that in that situation, if an employer tries to reconsider, tries to increase the penalty at a later date based on new evidence or based on looking at a larger look at the record, no, we raise the defense of double jeopardy, and we often win those cases. Next, Chris. Okay. This was going to be a topic that really has to do with investigatory interviews, because, and let me spend a few words on that now, although I'm probably falling behind. What I've said up to now is that an employer has a duty to conduct an investigatory interview with the employee before making a decision to impose serious level of discipline, that is a written warning or above. An oral warning, not so much. And an employer who issues an oral warning on an employee without conducting an investigatory interview, probably we couldn't win that case. Probably most arbitrators would not find in the union's favor here because the penalty is so mild. But when you start getting into written warnings, suspensions, and of course discharges, the rule that says that you must conduct an investigatory interview is well established and well enforced. Now, the other reason why it's important for unions to raise these points is that when a worker is called in for an investigatory interview, it's not just the worker and the supervisor discussing what happened. Because under a very important Supreme Court decision called Weingarten Company, the Supreme Court stated that when a worker is called in for an investigatory interview or disciplinary interview, that if that worker requests the presence of his or her union representative, and that could be a steward or a delegate or a chief steward or an officer of the union, if that worker makes that request, the employer must stop the questioning and allow the union representative to attend the meeting and to assist the employee during the rest of the interview. And these are called Weingarten rights. And this is a topic that all stewards in particular should become quite familiar with, because stewards have certain rights at these interviews that they need to be aware of, and many times they're not aware. Do we have a screen on that next? Okay. These are the rights that the steward has at the investigatory interview. And this comes from the Supreme Court. First, the steward can ask the employer before the questioning begins. The steward arrives at the meeting. The worker is called in for a meeting with supervision. The worker asks for his or her steward. The steward is called and comes to the meeting, enters the room, and now management wants to begin its interview. At that point, no, that steward has an important right. And what is that right? That the steward's right is to be told the reason for the interview. The steward has the right to say to management, excuse me, politely, before you begin your questions, I need to know, because I'm here to advise this employee and to assist this employee. I need to be told the reason for this interview. That is the type of misconduct, the type of wrong that is being investigated, and that leads you to call this worker in for an interview. Now, the employer has to respond to that request. It has to cooperate with that request. It has to give you the reason for the interview. It doesn't have to give you all of the evidence, all of its witnesses, all of its facts. It doesn't have to give you the whole story, but it must give you in a summary fashion the reason for the interview. We are concerned with this employee's poor attitude towards his supervisor. We are concerned with absenteeism or tardiness. We've had a report that this employee might be using drugs during his work. We've had a report that he's bothered other workers on the job, or he's harassed other employees. So we need to be told, in the general sense, the reason for the interview. At that point, we have a second right. And the second right is to request the opportunity to meet privately with the employee. In other words, to have what's called a caucus with the employee. And if we request a caucus, and we should, in almost all cases, ask for an opportunity to have a private discussion with the employee, a caucus, the employer has to allow us to move forward with that. How does the caucus get held? Well, the employer and its agents can leave the room, and we're now alone with the employee, and that's the caucus. Or you're alone with the employee, and that's the caucus. Or you and the employee could leave the room and hold a private meeting in the hall, or maybe another room. And the employer must afford you a reasonable amount of time to discuss the case with the employee. Third right of the steward is to advise employee on how to answer questions. When we meet with the employee in the caucus in particular, we're going to get the full story. Once we get the full story, or a good part of the full story, then it's incumbent on us to give this employee some help, some advice on dealing with the supervisor when we go back in the meeting. And that might be, there's a variety of types of advice. One type of advice is to encourage the employee to give short answers. Another piece of common advice is to encourage the employee to be calm, not to blow his, not to get upset, not to make accusations, not to call everybody a liar, not to deny everything. Because sometimes employees think they can talk their way out of things, and they deny every allegation that comes at them. If the employer says to them, "Isn't it true you were at work yesterday at 3 o'clock?" The employee may say, "Well, I'm not sure I was. I don't think I was. No, I wasn't on the job at 3 o'clock." Well, it's quite obvious that he was on the job at 3 o'clock, and it doesn't make sense for the employee to deny that. When the employee denies that, it calls into question his or her credibility on the other more important questions. And you, as the steward, might want to point out that to the employee that you don't have to deny every allegation or every point that's made to you. And a final right that we have at these meetings, when the questioning is pretty much finished, and before everybody leaves the room, the Supreme Court says that we have the right to point out justifications, excuses, and mitigating and extenuating circumstances. In other words, to point out facts or history to the supervisor, so that when the supervisor leaves the room and sits down and tries to decide or does decide what to do, they have some additional evidence that they may not have been aware of. You might want to point out, for example, that this employee is one of the best reporters on the paper, and it's well known. This employee has won these awards. This employee has cooperated and has worked extra time to help the employer meet deadlines or to cover stories. And there may be some personal factors about the employee that didn't come out in the questioning that you want to put on the table. For example, this employee may have been under an extreme level of mental stress that may have affected his or her actions. The employee's spouse may have left within the last few days, leaving the employee completely adrift after a long relationship. There might have been a death in the family that has made the employee sort of upset the employee in a way that affected his behavior on the job. Or there may be a death in the family. There may be a medical problem that the employee was not aware of that is surfacing and is causing the employee to be distracted or to get upset more than he or she should from small stimuli. So this is what the steward can say at the wine garden interview. Next. I'm going to skip double jeopardy for now. It's a really interesting topic. It's in my handbook. You can read about it. Let's move on to the fourth basic principle of just cause, and that is substantial proof. Employer is not able to impose any type of serious penalty without substantial and credible evidence. And when we come to evidence, that is, an employer can't make a decision based on rumor, supposition, guesswork, hunches. Employer must have substantial and credible evidence, which is usually eyewitnesses or written documents that establish that the employer violated the company's policy or handbook. One of the big questions that come up on proof has to do with hearsay evidence. Let's go to, I think it's on the next screen. So I think we're all aware from watching Perry Mason, et cetera, that there are three types of evidence: direct evidence, circumstantial evidence, and hearsay evidence. And direct evidence means there's a witness who saw the worker leave the work site or steal things, or saw the worker engage in harassment, or saw the worker sleeping on the job. Circumstantial evidence is not a direct witness, but facts which logically lead to a conclusion. If you find stolen items in an employee's trunk because you're checking the cars leaving the workplace, maybe, and you ask the employee to open his or her trunk, and there's stolen items from the shop. Okay, is that direct evidence? No, because the charge is theft, obviously. There's no witness to the theft. We don't know, we have no witness that he put those items in his trunk. Some other worker could have put those items in the trunk, but it's circumstantial evidence. Stolen items in the trunk logically leads to the conclusion that the worker stole those items. And now the burden is on the employee to overcome that evidence and to refute that. But that circumstantial evidence is okay. In many cases are proven by circumstantial evidence. The third category is more interesting to me: hearsay evidence. A lot of times, employers try to convict employees at arbitration, in particular, based on hearsay evidence. Hearsay evidence is a statement or either oral or written or transcribed from someone outside the room, outside the hearing room, which the employer tries to put into the record, and that person does not come to back up the statement. So the witness is testifying through a letter, through a recording, through an affidavit, through a document, which is not the employee, which is not the witness. There's no way to cross-examine the witness. It's unfair to the union, to the employee, because we are expected to listen to evidence come in against us, and we can't cross-examine the person who's responsible for the evidence. Hearsay evidence is not good evidence. Now, hearsay evidence, that doesn't mean the employer can't put in hearsay evidence. The general approach of labor arbitrators is that an employer can put hearsay evidence into the record. However, I will not convict an employee of a serious offense and provide a serious penalty solely based on hearsay. If you want to discharge a worker, cannot build your case solely on hearsay. So, for example, what would be a case solely on hearsay? If you're a worker and your job is to go and install cable vision in people's homes, and a homeowner is upset with you for some reason or other, and calls in to the company and gives a report that you harassed her in her house, you propositioned her perhaps. In any case, you were rude, you were over the top, and you upset her and scared her. Okay, that is a report by a potential witness. Employer can begin an investigation based on that report. Call you in, talk to other workers, try to get back in touch with that witness to see if the homeowner will flesh out the accusations. And now the case moves along, and on the basis of the investigation, employer determines to discharge you. Now that discharge is based on a combination of circumstantial and hearsay and direct evidence, you might say. Or you might take a different look at it. It's not so important as to how the employer made its decision. Where this becomes important is when we challenge that decision. When we challenge that decision, we end up at an arbitration. An arbitration is a legal proceeding which is supposed to be conducted in a particular format with protections for the person who's targeted with the accusations. In particular, if the employer comes to that arbitration, and if that homeowner doesn't come to the arbitration, and the employer puts in a case based on a letter that they got from the homeowner, based on a phone call from the homeowner, and maybe they transcribed that phone call. Maybe they made a transcript of that phone call, a recording of that phone call. These are all other ways of putting evidence into the record, but that evidence now has the character of hearsay evidence. It's evidence that was of what happened outside of the hearing room by a person who is not willing to come to the hearing and to be subject to cross-examination. In that situation, we should win the case. The arbitrator is not, if he respects the weight of arbitral precedent, he should either approve the grievance in its entirety or substantially reduce the penalty, because that arbitrator should not sustain a discharge which is based 100% on hearsay accusations. Let me give you a different way of looking at this. Many times we are accused of misconduct by a supervisor. Let's say insubordination or failure to follow an instruction or an order. It's a strong accusation. Insubordination is a serious accusation. It leads to serious penalties. But many times, by the time we take that case up to arbitration, which is 3 months or 6 months later, what happens? We go to the hearing room, and what happens? The employer summarizes its case, and then when it comes time to call its first witness, who's not there? The supervisor is not there. Why is the supervisor not there? The employer would like the supervisor to be there, That's how the best way to put on the employer's case. Why is the supervisor not there? Could be one of many reasons. One, we find that the supervisor has quit in the meantime. Two, the supervisor could have retired. Three, the supervisor himself or herself could have been fired. Or four, the supervisor may be ill, the supervisor may have died. These are various reasons why the direct witnesses don't show up at the hearing. In this particular case, where a supervisor is making an accusation, the employer now is in big trouble. Doesn't have its direct witness. Tries to put in the evidence through other forms. And probably what the employer will do in that case is attempt to put in an affidavit. The supervisor probably completed an affidavit of what happened the day it occurred. It's called an incident report. It's in the record. The employer makes a motion. I want to move to enter the supervisor's affidavit into the record as exhibit number 1, which lays out what happened in the case. Well, we're going to object as the union. The arbitrator is probably going to allow the employer to put the affidavit into the record because in labor arbitrations, arbitrators are very relaxed when it comes to putting things in the record. But the way the arbitrator gets back at the employer is by saying it's in the record. But if this is all you have to say that this employee committed insubordination, I cannot uphold the employee's discharge or even the employee's suspension. You know, if you want to come up with a lesser penalty, I might buy that. But I will not give this employee a serious penalty based on hearsay evidence alone. So this is something to think about. If we know that our primary witness against us is not going to be present 3 months from now at an arbitration, it influences. But this whole, winning these cases really depends also not only on identifying hearsay, making the right objections, but also it's very important that in these kinds of cases, the employee have a consistent case of denying the accusations against him, or denying the accusations against him. If this Cablevision report comes in that the employee harassed the homeowner or was rude, and that employee is called in for the interview as he or she would be, and if at that interview the employee does not deny the charges consistently, then that becomes an admission. If he admits part of the charges or a little of the charges, yes, maybe I did this, maybe I did that, that may be enough to convict because that becomes an admission. An admission overcome hearsay. That is, admissions are in fact considered direct evidence, and that's enough for an arbitrator to uphold serious penalties. Okay, next. Okay, I'm going to spend a few minutes on principle number 5, equal treatment. What does this principle say? Unless a valid basis justifies a higher penalty, an employer may not assess a considerably stronger punishment against one employee than it assessed against another known to have committed the same or substantially similar offense. Another way of summarizing this principle is the notion of disparate treatment. The union wants to establish that the employer committed disparate treatment. It treated 2 employees differently when they had committed the same type of misconduct. And it did not have a it did not have a valid basis to justify differences in penalties. An employer doesn't have to give the same penalty to every 2 employees who commit the same offense. It can consider other factors. There are some valid bases to give one employee leniency and another employee a severe penalty. For example, if we have 2 employees and they each showed up for work inebriated or under the influence, and they were slurring their speech and they weren't walking clearly, properly, employer can charge them with intoxication and impose a very serious penalty. It's considered an egregious type of offense, and can either discharge them or suspend them. It can give them quite a penalty for coming to work under the influence. However, if one of those employees has worked there for 35 years and has a perfect record and is one of the best workers in the shop and is well respected and tries to help out in any way possible to make the employer business a success, And the other employees only worked there for a week, and during that week had a kind of a rotten attitude, and left work early on three of the days. In that situation, we have two employees who committed the same kind of misconduct, came to work under the influence. But there is a valid basis to give the employees different penalties. There's a valid basis to give the short-term employee a very serious penalty, including discharge, at the same time as we give, a week later, we give the long-term employee a much less heinous penalty, such as a written warning, a 1-day suspension, a 5-day suspension. So there are situations where another situation might be two employees, drivers for a company, drive trucks, and they have accidents on the job. Fairly similar facts, but one accident causes $10,000 in damage to company vehicle. Another accident just leads us to a scratch. But otherwise, they're fairly similar types of accidents. Maybe in both cases, the employee was at a red light and started early and hit the car in front of him. One case, it leads to a scratch. Another case, it pretty much destroys the company truck. That difference in penalties is a valid basis for a different penalty. The employee who committed $10,000 in damage is probably going to get a very severe penalty, if not discharge. The employee who did the same thing but got a scratch is probably going to get a lesser penalty, and that's accepted. That's accepted. So there are situations where you can give different penalties for the same type of misconduct. But by and large, if the employer can't point to a really valid basis, then we have a situation of disparate treatment, where two employees are treated differently without a valid basis. And when we have two employees treated differently without a valid basis, then it's not fair. Then the general rule is that the employer is expected to apply the lowest penalty. That is, if one employee got a low penalty, the other employee needs to get a low penalty. And if one employee got a low penalty, another employee got a high penalty, then what an arbitrator will often do in these situations is reduce the penalty for the employee who got the severe penalty down to the level of the employee who got the light penalty. Another way of looking at this is that we are looking to win these cases. We are looking for someone who you could call a comparator. A comparator is another person who works for the employer who committed the same offense, or the same misconduct, but got a significantly lower penalty. In a lot of our cases, we have no other defenses except equal treatment. But if we do our work, we will oftentimes find a comparator, someone who got special leniency, who got a break from the employer. All we need is to find one other employee who got that break. And if the employer can't justify that break, then we would expect the arbitrator to reduce the penalty on the person that we're representing down to the comparator. It would be nice if we could find several comparators. That makes our case more attractive. But there are many written arbitration decisions which we could show the arbitrator, or which we know about, where just one comparator is enough to reduce a penalty. Now, it's interesting because employers are aware that unions win a lot of cases when they prove disparate treatment. So maybe this is the biggest defense that we have. So I think when I know employers conduct training of supervisors, one of the points they certainly make is that when you impose penalties on employees for violating workplace rules and policies, it is important that you apply the same penalties across the board. Because if you don't do that, the union will this is a union shop, and they will catch us, and they will raise this in the grievance and arbitration process, and we will be forced to reduce the penalty on the high disciplined worker. So they do this training and they do explain these points. Nevertheless, it's very difficult to find a workplace where there is no form of favoritism. It seems like favoritism is there. It seeps in. It's on the edges. It crawls in. It's always there. No matter how anxious management is to get rid of it, it comes back in. For example, A employee might be the best worker in the department, the finest reporter, the fastest reporter, the most respected reporter. He comes to work under the influence. He's using marijuana on the shop, or he doesn't check a story. Well, you're not going to fire him. I mean, it's going to be a big impulse not to fire him because he's the best employee or she's the best employee. So consequently, that they pass it over. Instead of giving that employee a discharge or a suspension, they give that employee maybe a written warning or an oral warning. In another situation, it might be that an employee is related to management. That is, that the employee who committed the offense is a relative of the owner or a relative of the director. Well, the supervisor is not going to fire that employee or give that employee a serious penalty if he can help it. And so he reduces the penalty. He gives them a lenient penalty. In another case, the employee might have a relationship with the supervisor, might have a romantic relationship with the supervisor. In that case, the supervisor is not going to impose a severe penalty, even though he did that for other workers. In another case, you have a worker who is a union snitch. That is, this is a worker who is cooperating with the company, is informing on the union, is telling the company everything that the union is doing. And now this same employee violates a significant work rule. You're not going to fire that employee. They need that employee. So they give that employee a break and they give that employee a second chance. Instead of firing him, they give him a last chance agreement, or they give him even a lesser penalty. For one reason or another, if you do your work, what I'm saying to you is if you do your work carefully and investigate, go back further, you will find one or more comparators. Now, the best comparator is a person in the same department who did the same violation or offense. That's the best. But if we can't find someone in the same department, we'll go outside the department because employers are expected to apply workplace rules similarly throughout the workplace. And if we have a truck driver who is treated more leniently than someone in maintenance, that's a violation. We should win that case on disparate treatment. Sometimes we can't find someone in the bargaining unit, in the union bargaining unit. That doesn't stop us because we will often go outside the bargaining unit. We can go outside the bargaining unit and look for comparators among non-union staff or members of other unions. So, for example, if we have an employee who has been given a suspension for smoking on the workplace, and especially in a room where it's dangerous to smoke because of there's materials in the room, and he's fired for creating a hazard. We may not know of another employee in the union who did the same thing, but we may know of a supervisor who is known for smoking in that room, that same room, and several people have seen that supervisor. And in fact, we happen to know that on one occasion, upper level management even spoke to that supervisor about not smoking in that room anymore. So management is aware that someone else violated the rule. Now that worker, that person is not in the union, but we are allowed to bring that person up as a comparator because the rule that is accepted among labor arbitrators is that, once again, an employer, if there's a rule that applies within and without the union, that is within the union bargaining unit and outside, if there is a rule, the employer is expected to apply the rule the same. Now, there are some rules that don't apply outside the bargaining unit. Lateness is maybe tardiness, maybe one of them, because management, they can be late, they can work late to make it up. They may have somewhat different rules on lateness. But when you take a look at many other rules, in many other cases, the rules are the same. No fighting. Nobody in the union is allowed to fight with other people, have a physical altercation. If they do, probably get fired. But that rule, no fighting, on the premise, it applies to management too. It applies to managers, bosses. It applies to inspectors. It applies to secretarial staff. It applies to guards. It applies to the whole workforce. They can't deny that. If we raise that and we make that allegation, this is a rule which applies throughout the whole workforce. Believe me, management is not going to take the stand and say, no, that rule doesn't apply to guards. Oh yeah, sexual harassment, that's a rule that applies to the we made that clear. It applies to the union workforce. But doesn't it apply also to management? Well, yes, well, maybe, yes, but yes, it does. And so the point remains: where there's a rule that applies within and without the union bargaining unit, management has to apply similar rules. I mean, maybe not exactly similar as they might within the union, but very close. If we have a worker in the union who's fired, and we have someone in management who's given a slap on the wrist, maybe told to go to a program to learn about alcohol, that is disparate treatment, and we should win that case. One of the main ways we get our evidence on disparate treatment is by making requests for information to the employer. In my book on the legal rights of stewards, I have a chapter called Request for Information. It's something I have often stressed. We need data to win these cases. We need records. We need records which show that other employees committed same offenses. We need the records of a notice of discipline. We also need the records which show the penalties that were imposed. We also need the records to show whether there was any reason for which this employee justifiably was given a lenient penalty. We need records, and we get those records by submitting detailed information requests to the employer to build our case. Records which require the employer, at the minimum, to give us the personnel records of other employees who we want to compare ourselves to, but also require the employer to give us a history of how they handled the case, what they did, what arguments were made, and how they responded. Now, one of the problems that happens with equal treatment is sometimes we think we come across a case and we get very excited that we're going to win. We have an employee who was guilty of charged with theft 2 years ago, and that employee is still on the job. That employee that employee was not fired. That employee we have now a new employee who is charged with theft and was fired. So we think, wow, we have another worker who was charged with theft and wasn't fired. Now we have a worker who was charged with theft and was fired. But when we look into it, it turns out that the first worker who wasn't fired, he was fired. That is, the employer initially fired that worker for theft. Then the union grieved that penalty. And during the second or third step of the grievance procedure, the union worked out a settlement with the employer, reducing the penalty from a discharge to a 30-day suspension, and also that the worker agreed to enter a program to deal with emotional or other issues, private issues. So we have a settlement agreement. Well, that doesn't kill us, because the settlement agreement just means that the employee reduced the penalty and they treated him differently than the employee that we represented. But the kicker is that within that settlement agreement, there's a sentence that does come back to haunt us. And that sentence is that the employer puts into the settlement agreement that he's settling the case without prejudice. Without prejudice. 2 words, without prejudice. What does without prejudice mean? Well, it has acquired a big connotation in labor relations. It means that we're settling this case, but you cannot use this settlement in any way to help other employees in their cases down the line. This case cannot be raised or cited as a precedent for you to bring an equal treatment case on behalf of somebody else. So when an employer settles a case without precedent and the union signs that settlement, as it almost always does, well, that wipes out that comparator. We can't use that employee as a comparator. If the company happens to reduce the penalty in the settlement agreement, it doesn't put the words without prejudice into the agreement, we're okay. We're going to raise that up. We're going to put that in front of the arbitrator, and we're going to ask for the same action we taken for the employee that we're representing. Next. Okay, well, actually, here is an example of an information request that we're going to submit in our search for a comparator. So we're going to give a letter to the employer. We're going to ask, 1, for the names of all other employees and former employees who committed similar offenses over the past 5 years. Because we want the ex-employees also. We could sometimes build a case based on what happened to an ex-employee. We want to know the discipline that you imposed. We want to know details of the offense. We want to know details of the employee's record, how many years of service the employee had, and whether the employee was guilty of any other infractions. And we want you to tell us why you imposed a lesser form of discipline than what you have imposed in the case that we are handling right now. Next. All right. We only have a few minutes left, I think, of the to go through the 7 principles. So I'm going to very briefly go on number 6 and 7. Progressive discipline. As I mentioned to you earlier, progressive discipline is considered to be a component of just cause. And progressive discipline says that when you respond to misconduct that is short of egregious, the employer must issue at least one level of discipline, or degree of discipline, that allows the employee an opportunity to improve. And in fact, many arbitrators will ask that you issue 2 or 3 levels of discipline before you move to discharge, but at least one, and then sit back and see, does the employee respond to that discipline and improve and stop doing what he was doing that led to the discipline in the first place. And when we talk about progressive discipline, we need to distinguish industrial discipline from criminal discipline. When you commit a crime in society, there's no requirement of progressive discipline. There, the state can impose a penalty on you for of a very serious nature, whether or not you've had a prior penalty. And in fact, a lot of people would say the main purpose of punishment in the criminal world is punishment. The main purpose of imprisonment is to punish you, is to make you feel bad, is to hurt you, and also to set an example for other people not to do the same thing. Well, in the industrial world or the workplace world, those concepts really aren't proper. Industrial punishment is not to serve as an example or to hurt you or to make you feel pain. The purpose of industrial punishment, it is well agreed, is to give you, to see if you can improve your condition so that you can rehabilitate yourself. The purpose of punishment in the industrial world is to prompt the employee to improve, to change, to be rehabilitated. Next. One of the components of progressive discipline that's pretty well established is that an employer must apply, in fact, the lowest level of discipline that is likely to lead an employee to correct his or her behavior. So if an employee commits some type of misconduct, negligence, harassment of other employees, fighting, marijuana, drugs, or whatever, the employer is supposed to apply the lowest level of discipline that is likely to lead the employee to correct his or her behavior. So the employer has to look at the employee and the whole picture, has to look at the whole picture as to what the employee did, what else we know about the employee, and then come to a conclusion as to, will this employee improve based on a low punishment, or do we have to give this employee a very severe punishment to get this employee to improve? For example, if you have an employee who has worked in a workplace for 30 years, that employee is invested in the workplace. And that employee does not want to lose his or her job, and will do anything not to lose his or her job. It may well be that all you have to do to this employee is to give this employee a written warning of misconduct, with a threat that if the misconduct was to continue, you would have to move to higher levels of discipline, including the possibility of discharge. Maybe all you have to do is put that in writing, and this employee will now become, a 100% perfect employee, because this employee has so much to lose. Now, with an employee who's only been there a few weeks or a few months, in that case, a more severe penalty may be necessary to jolt that employee, would force that employee to take the matter seriously. Let's go to the next screen. The last of the 7 principles of just cause is called mitigating and extenuating circumstances. And this principle says that when an employer determines the proper level of discipline to apply to a worker or employee, the discipline must be proportional to the gravity of the offense. Well, that sort of goes to what we've talked about before. Given the gravity of the offense, you need a stronger penalty to shock the employee into not repeating it, but also taking into account any mitigating, extenuating, or aggravating circumstances. We'll talk about aggravating later, but mainly mitigating and extenuating. Mitigating circumstances are those factors that relate to an individual, which suggest factors that relate to the individual's own personality or own personal history, that suggest that this employee is not as bad as you think he is, or is not as much of a wrongdoer as you initially thought. Extenuating circumstances are factors where part of the reason why the employee committed the infraction has to do not only with things that he or she did, but also comes from management. That is, management is partially at fault in some way in causing the infraction. When there are extenuating circumstances, that also reduces the culpability of the employee. He's not as guilty as you thought he was to begin with. It doesn't require as severe a penalty as you might have originally thought. Very quickly, a list of mitigating circumstances. Next. These are considered mitigating circumstances: length of service, quality of record, age, employer fault, provocation, medical condition, fatigue, and employee takes responsibility. Let's just take the last one right there. You know, some unions say that the main way they win cases, disciplinary cases, and I don't know if this is true or not, is that they encourage the employee during the wine garden interview to go back to the interview and to accept full responsibility for what happened. Don't try and talk your way out of it. Don't give excuses. Don't try to cite your medical problems or your family problems. Take responsibility for what happened. Promise that you will not repeat the conduct. Agree to go into any program the employer might ask you to go into to be a responsible employee, to show responsibility, to show that you take it seriously. And some unions say that's the best way we have found to convince the employer to impose a modest or lenient penalty. All these mitigating circumstances are things that we should bring up during the disciplinary interview and ask that the employer take them into account. All of these factors are things that we should bring up at arbitration to try to convince the arbitrator that a harsh penalty is not necessary for this particular employee. There's more to the picture. Look at the whole picture of this employee. He's not as serious a wrongdoer as the employer is trying to portray. Let's go to the next screen. Extenuating circumstances. Once again, extenuating circumstances are situations where part of the reason the employer screwed up is because the employer screwed up, because the employer didn't do its job correctly. For example, the order that the employee disobeyed or failed to fulfill may have been very poorly communicated. If you look at the instructions, it's vague. It's not precise. Even if it's an oral instruction, the employer mumbled when he speaks. The employer it's hard to understand. Second, inadequate training. It may well be that the reason this employee felt that he couldn't fulfill the order from the employer was that he was never trained on how to do that work, how to do it properly. The reason that the employee had an accident on the job, inadequate training. Provocation. Yes, the employee may have cussed out the supervisor, may have threatened the supervisor in some minor way, but he was provoked because right before the employee made those statements, this supervisor was harassing this employee, was giving that employee extra work without cause, was insulting this employee up and down. Harassment by supervision is an extenuating circumstance. Failure to call problems to the employee's attention. Supervision knows the employees are doing the job wrong and doesn't bring it to the attention of the employee. Consequently, the employee starts doing the job even worse and worse, or repeating repeating the wrongdoing or the problems. That is an extenuating circumstance. Partly the responsibility of management has to be taken into account when determining whether to discharge or give the employee serious. And the last one is supervisor sets a bad example. A supervisor who does the same thing that he's accusing the employee of doing, well, that's not right. I mean, if the employer is setting a bad example, then the employee shouldn't be punished for following that example. So that completes my presentation, and I think we can take a few questions. Sometimes it works out, and sometimes it doesn't.
Thank you so much. That was so great. We have a number of really excellent questions, so I hope we can get through most, if not all of them. First of all, is there a standard legal definition for gross insubordination?
Well, there's definitions of gross negligence, but gross insubordination, it doesn't come to my lips immediately. There probably is, but there may be. But insubordination is insubordination. Insubordination doesn't have to be gross to warrant severe penalty. Insubordination, refusing an employer order, is a very serious infraction, and in many workplaces, the standard penalty is discharge.
On the question of notice, if an employer decides to start using a performance review system that has never been explained to employees and using that as a basis for compensation and discipline, can that be challenged on the basis of just cause?
Well, if it's a compensation system, the basis of how you pay people, you're rewarded based on X, Y, and Z. We wouldn't, if we felt an employee had been cheated or treated wrongfully under that system, we wouldn't file the grievance under just cause because the employee hasn't been punished. The employee didn't get paid the way we think he should have been. If the employee, so I guess my answer to that one is probably no.
Okay. What advice do you have for a steward preparing a fellow member for a disciplinary interview? What should you prepare beforehand?
Well, you said a fellow member? I mean, a member of the bargaining. Well, of course, this all takes place very quickly. You generally don't have too much advanced knowledge. You're called in, there's the worker, here you are, you ask the employee for a private meeting, and at the private meeting, you try to prepare the employee so he doesn't do anything at the meeting that gets himself in more trouble. After all, sometimes the employee doesn't have the goods on the worker, but the employee composes himself at the meeting in such a horrendous fashion that he gets fired for how he handles the meeting. He insults the supervisor, he yells and screams, he uses high levels of profanity. Well, we need to guard against that. But as you do the job more and more, you begin to pick up on those things which get people in trouble, and those are the things that you're probably going to stress the most. One thing that I think is sort of interesting. A lot of times when an employee is called into a disciplinary meeting, the first question the employer may ask is, "Okay, you are aware, are you not, that the following conduct is a violation of company policy?" So you are aware, are you not, that failure to get permission before you leave the premises is a violation of company policy, okay, or whatever the violation is. And you are aware that the penalty for this infraction can be quite serious, up to and including discharge. So this is like a groundwork. They're laying the groundwork. At the same time, there's a trick to this because they want you to say yes and yes, simple two yeses. Those two yeses may come back to haunt you because later on you might want to make a case that the employer, that you did not believe there really was a rule requiring you to get permission, because yes, there is a rule in the rule book, but the employer hasn't enforced that rule for the last 2 years, or at least hasn't enforced it in your department. Consequently, you read that, you looked at that and concluded quite logically that the rule was not in place, that there may be a rule in the rule book, but the rule didn't apply in your department because it had not been enforced. So you want to be able to make that argument later on. Consequently, when you come back to the disciplinary interview and the question is, you're aware that there's a rule that you have to get permission before you leave the workplace. You might not want to answer that question yes, and you might want to advise the worker that that's probably going to be the first question or one of the early questions. And in that situation, what you might want to answer is that I'm not sure. That yes, there may be a rule, there may not. I see facts that would suggest that there is no such rule, because I look around, I see other people doing it, and nothing happens to them. So to me, that suggests that there is no rule. So I can't say to you that yes, I know there's a rule. So that would be a nice little bit of advice that you might give.
In those settings, should stewards be information gathering or should they be argumentative?
Well, not argumentative, because a disciplinary interview, the Supreme Court said this, you're not there to bargain, you're not there to argue. You're there to assist the employee in answering the questions. You can give the worker advice on how to answer a question. You can whisper in the worker's ear, you can say it out loud, you can encourage the employee to calm down, you can remind the employee of some facts that the employee might have forgotten when he answered the question initially. You can assist the employee, but you can't argue and you can't bargain. You can't certainly go in there and say to the employer, this is ridiculous. Why are you talking to this worker? You should be talking to employees Y or Z. They're the ones who know more about it. So that's trying to displace the interview, trying to end the interview. The employer has a right to conduct an interview as it sees fit, by and large. This is not a bargaining session. It's not a grievance session. We're there to assist the employee in answering in a truthful and a full manner, if possible.
In the editorial world, just cause can be a fuzzy area if an editor is subjectively dissatisfied with the reporter's writing, for example. How can just cause protect workers over creative differences with their managers? Can subjective criteria be used to counter just cause?
Well, that's a good question, and probably people here are in a much better position to answer that, since I don't think in all the unions that I've worked with, I've ever had writers or people who work who do creative work as my clients. But if we were in a dispute as to whether the quality of a person's work, the employer says the quality of the work is lousy, it's below average or below norm, and we think it's average or above average. How do we establish that? I imagine one possibility that would just come to me would be to get the opinions of third parties who could look at it and sort of expert witnesses, if you will, we would call in as witnesses, say, I read the story, it's an excellent story. Something like that.
Okay. When finding a comparator for purposes of equal treatment, do the employees need to have the same manager?
No, they don't. And a lot of times the employer's excuse, oh yeah, you're pointing out an employee who did the same thing and got just a slap on the wrist. That's because the supervisor in that department, that's his philosophy. He doesn't believe in severe discipline. He believes in talking about things, and that's his philosophy. But the philosophy of your supervisor is different, and he's entitled to his own philosophy. Well, that's not true. Supervisors are expected to apply rules of conduct in an equal manner throughout the workplace. Throughout the workplace, in each department, the same. That is not a winning argument it should not be a winning argument at arbitration. And I can't imagine an arbitrator writing a decision that way, saying that, well, yes, there was disparate treatment, but the supervisors had different philosophies. That won't carry.
Do you have advice for grievances filed, denied, and moved to arbitration after the contract has expired? For context, it says we are in bargaining, but the employer often says that they won't arbitrate because they don't consider the subject of the grievance to be a vested benefit.
Well, there's a lot of rules about arbitration. When a contract expires, it is often said that the duty to arbitrate, although many things continue, many parts of the contract continue, the wage levels, the benefits are continued. unless they're bargained to impasse. But one of the exceptions is arbitration, and the folklore is, or the general understanding is that after a contract expires, an employer doesn't have to arbitrate new grievances. So if a person was to get fired or not paid correctly after the contract has expired, and the union can still file a grievance over a new matter, we have the right to grieve even though the contract has expired, and the employer has an obligation to meet with us even though the contract has expired. We can't compel the employer to arbitrate that case. Now, if the employee was fired while the old contract was in effect, if the employee was fired and we were in the grievance process and now the contract expires, we can take that case to arbitration, because that right has vested for that case. He was fired under the old contract, and we are resolving it under the old contract, which includes arbitration.
Got it. For our last question, would the pandemic and change of assignment in the same year count as extenuating circumstances?
Yeah, well, I think the pandemic and changes of assignment, I don't know what he means by what they mean by that, but certainly the pandemic, I can imagine many scenarios where we would be arguing that because of the pandemic and because of all the stress of the pandemic and family problems of the pandemic, that has made some of us unable to do the jobs in the same way they were doing them before the pandemic. I mean, you have to go into the details, but the pandemic is a legitimate outside event that needs to be considered in determining whether the employee committed the same type of misconduct before the pandemic might not be misconduct during the pandemic. I can definitely foresee that.
Great. Okay, that's all we have. Thank you all so much for coming to this webinar on Just Cause, and thank you so much, Robert, for your expert advice and intel on this.
Well, I enjoyed it, and I hope I'll see many of you at the last of these.
Yes, the next training is June 28th on past practices. I think we've got the link in the chat, so please sign up. It's going to be great, and hope to see you all there. Thank you so much.
Good luck.